Food and drinks are prohibited in the courtroom. At any time you may excuse yourself if need be, but be silent when you do it. We ask all onlookers to refrain from talking during the proceedings to ensure a fair and safe trial. Pictures and videos are strictly prohibited in the courtroom without an authorized media pass from the San Andreas Judicial Branch. At this time, all rise for the Honorable Associate Justice Judith Mason.
Thank you, ladies and gentlemen. You may be seated. So today we are discussing, this is a motions hearing for the case of 22 CM0017, State of San Andreas versus Frank Raven. Mr. Raven is here representing himself for the defense, and we have Attorney Rashid Briggs for the prosecution. To start things off, we're just going to be going through the motions that have presented thus far, beginning with the motion for discovery of officer statements submitted by the prosecution. Attorney Briggs, if you would please explain your reasoning for that motion.
Thank you, Your Honor. I would like to state as a prosecution that the statements that were provided by the police officers for this case are absolutely necessary, as they provide a very good foundation about what happened and their perspective on the whole issue. So we believe that, in the exhibits that we have presented as evidence and personal statements, they are necessary for the case to move forward.
Very well. Mr. Raven, is there any dispute about these exhibits submitted in this discovery? I understand there's a further motion to suppress, but you may begin.
Yes, Your Honor. The defense in this matter, with regards to the prosecution's exhibit number 1, contends that the statements made by the officer lack any foundation, particularly the parts that mention the sources of the money being of an illegal nature. That has not been established by the prosecution or the officers during the arrest. Just a moment.
Sorry, was there more beyond there? Go ahead.
I'm not sure if you want to, if Your Honor wants to argue these exhibits one by one, or if you would like me to make my full argument as to the full motion in itself.
We'll go one by one. Mr. Briggs, if you would like to respond to that initial issue with Exhibit 1 for, I believe it was Officer Babatunda, the statement provided.
Absolutely. Ms. Mason, we have requested the personal statements from the police officers, and as a matter of fact, they're just statements. The prosecution does not believe that we have to establish anything for a personal statement, as it serves as only the opinion of the person that, and the correction of the events of a person that about what happened. Obviously, the foundation for other kind of evidence will be necessary, but not for personal statements, we believe. So that is our response to that.
Mr. Raven, rebuttal?
Your Honor, the prosecution currently is trying to state that the information provided by Officer Babatunda serves as proof that the arrest was lawful, specifically the claims that the packed cash was obtained illegally and that they can only be obtained illegally. As such, because they do want to use this evidence or this exhibit as evidence against the defense, we look for them to provide some sort of foundation for these statements.
Very well. Mr. Briggs, a response to the...
Your Honor, in our Exhibit 1, we have stated that the prosecution believes that this statement is crucial towards their case because it provides, the cause and the reasoning behind the charge. Obviously, we're not claiming that, anything about the search or anything about if it was unlawful or not. It gives the reasoning behind the charge, and that's what we have stated initially. Nowhere we have stated that about the search or the initiation about it. We have requested that this is initiated as a statement, and it's just a statement.
Very well. At this point in time, I will be allowing this exhibit. However, the statement stating that it's incapable of being received from any legal sources will be taken with a grain of salt. Obviously, more foundation to establish that as a fact will be, well, obviously would be much beneficial to the prosecution. But Mr. Raven, your concerns are duly noted. At this point in time, we can move on to Exhibit 2. Mr. Briggs, is there anything specific you would like to say about this exhibit before I hear from Mr. Raven?
Yes, absolutely. The prosecution here would like to state that this is a picture of the packed cash that was found on Mr. Raven. Now, he is trying to establish that this was an unlawful search, which I will be explaining further in the motion to suppress. But for now, would like to state that this just presents what was found on the scene. And we believe that evidence such as this plays a crucial role to the charge that was placed on Mr. Raven, and it should be something that is admitted to the court, as without it, the basis of that charge has no foundation.
Very well. Moving on to Mr. Raven for this piece of the discovery.
At this time, Your Honor, the defense would like to object to this exhibit, particularly the added paragraph that comes before the actual physical evidence, namely the following statement. As Your Honor, the defense would argue that the statements made before the presentation of the physical evidence once again tried to establish the fact that this packed cash somehow comes from a bank or has been stolen. No such foundation has been laid but to prosecution at this time of that being the case.
Very well. Any response from Attorney Briggs?
Yes, Your Honor, I would like to state for the fact, and here in front of Mr. Raven, that I believe that he has confused a little bit what contains the before the evidence that we submit. It's just information. We are not. It's not the actual court. Whatever we state there is what we believe, and it's our own thoughts as the prosecution. We're not arguing anything. We are just stating why we think it will help us and why we think that the judge should allow us to use this information. Mr. Raven is trying to, for some reason, present it as something that we're arguing in court. We just want to state that it's just information and background on what we believe that this will help us in, and giving a little bit of information to the judge. We're not arguing anything. We're not presenting anything to the court. It's just information that we provided.
Very well. A response from Mr. Raven on that matter.
Your Honor, the defense contends that if the prosecution wants to submit the physical evidence, this case being the packed cash, they can do so without adding any sort of information that they cannot provide foundation for.
Very well. At this point in time, I will be allowing the evidence picture to be admitted into evidence. But I guess I think we're on the same page here. The supporting information provided prior to the discovery is only intended for courtroom purposes and will not be used as evidence in the trial. It's just simply contextual information. But yes, your concerns are once again duly noted. At this point in time, we will be moving on to the next exhibit. That's going to be the personal statement provided by Los Santos Police Department's Sebastian Papadakis. Attorney Briggs, if you would go ahead with that one.
But yeah, the prosecution does not have any specific things to say about this. It's a plain statement from Mr. Papadakis, and that's all there is to it.
Any response from Mr. Raven about this piece of the exhibit?
Yes, Your Honor. The defense would like to object to this exhibit on the grounds of hearsay. Precisely from the 1 minute 26 seconds towards the end of the entirety of the video, Officer Papadakis can be seen or can be heard speaking for other officers or giving his own opinion about what other officers have said or their motives behind the arrest. It is not only a statement that speaks from his perspective, and as such, we would like that stricken from the record due to hearsay.
A response from Mr. Briggs.
Your Honor, again, he's objecting as hearsay, but it's not a court hearing. It's not the court that we're actually doing, but we will respond to this objection by Mr. Raven by stating the fact that in a personal statement, the person has every right to explain his situation and give context behind his actions, as Mr. Papadakis was not by himself during the time of the arrest, but he was also with another partner. And as we are well aware, police officers that work in partners do have to conversate before they take actions. So he provided context for his actions and did not provide any information about hearsay or did not give any opinions that are beyond his rightful, that he should be able to say.
Very well. One last response from Mr. Raven, and one more time, if you would give that timestamp that you stated previously.
Yes, Your Honor. So the timestamp for this case would be from 1 minute 26 until 3 minutes and 40 seconds. Just to clarify something, I understand that Prosecutor Briggs is trying to paint the situation as the officer having conversed with his colleagues. The defense at no point is trying to argue against that. We are merely stating that if a statement is to be submitted as evidence to the court, it should be a statement that avoids any sort of hearsay. If Prosecutor Briggs wanted to submit a video recording of an officer's statement, he could have done so in a deposition where defense counsel could be present for the deposition as well as object during the deposition.
Very well, and if you will just allow me a moment to review a little bit of that footage that has been provided during that timestamp. All right, so I have reviewed the footage. I think for this, in terms of hearsay, actually, Mr. Briggs, if you are aware of this information, was Officer Papadakis on the scene while this conversation was happening? Was he present? Was he there? Did he hear this conversation?
Can you repeat that question? I didn't really.
Yes. Was Officer Papadakis on the scene hearing this conversation when he was saying, we did this, we did that? Or was it simply more of a we as the police department were doing these things?
Yeah. So Mr. Papadakis is the officer that was on the scene and was actually involved with the police arrest. Now, I wanted to clarify that after reviewing the footage myself as well, I have not noticed any hearsay or anything other than the lines of recollecting how events turned out and the decisions that they took. And as Mr. Papadakis was an officer that was in the scene and conducted the arrest together with Jeff Babatunda, I believe that, the motion should be not allowed.
Mr. Raven, go ahead.
Your Honor, I would just like to point towards a specific timestamp within that video, that being 2 minutes and 40 seconds. That would be 40 seconds, where Officer Papadakis seems to be directly stating what Sergeant Breacher was informing the defendant of. The defense's statements right now is that Officer Papadakis was not present throughout the entirety of the arrest in regards to being next to the sergeant that was on scene, as well as his colleague throughout the entirety of the arrest. He could have been doing other such duties, such as setting up scene management or taking care of charges, and thus any statements that he makes with regards to what Sergeant Breacher said would constitute hearsay.
Mr. Briggs, go ahead.
Your Honor, the defense is changing up the claims that they're making in the middle of the hearing. They initially started by saying that from minute 1 and 16 seconds, there's hearsay, but now they're switching up to 240. Can they clarify specific parts of the tape? And the ones that they clarified, specifically the one at 240, it's speculation, due to the fact that he just mentioned that he might have been doing scene management, might have. We haven't seen any basis of or any information about the actions of the surgeon. So again, we do not believe that this is hearsay and it's just a recollection of events.
Once ahead, Mr. Raven, go ahead.
Your Honor, with regards to the first statement made, the defense provided these timestamp 1 minute 26 seconds and onwards towards the end of the video. That is because at that timestamp is when Officer Papadakis starts referring to himself and his colleague using pronouns such as ours. That is why we gave that initial timestamp. We then gave timestamp 240, that's 240, just to clarify another instance where hearsay was more clear. It was not to detract from our previous point. With regards to the defense's statements of the officer's actions that he might have been doing something else, we are not providing a witness statement. It is up to the prosecution to prove that the statement is not hearsay by providing the court with evidence that the officer was present throughout the arrest and fully focused.
Go ahead, Mr. Briggs, one more time, and then I'll be prepared to.
Again, we want to point out that this is not the court, and this is evidence that we plan on using. Giving evidence for evidence sounds a little bit contradicting by our part, but we also want to state that the objection of hearsay in this specific situation, it's only an objection raised when a witness is testifying. So again, we don't really see the basis of the objection here, Your Honor.
All right, very well. I will be allowing this exhibit to be used during the trial. However, I will be more aware that any statements that are intending to be used as specific evidence during that criminal trial will be subject to scrutiny if it does include hearsay. I imagine Mr. Raven will be saving objections for that time should the specific evidence be used in regards to that point. So again, once again, I will be including this piece of evidence. So we will move on to Exhibit 4, the LSPD's Knowing Your Rights and Due Process document. Mr. Briggs, go ahead.
Yes, Your Honor. So this is a document presented by the LSPD about what gives probable cause to police officers, and we believe that this document will be very crucial towards pointing out some of the reasoning and some of the actions that the police officers took, and justifies the actions that they took at the scene at that time. So yeah, that's what we have to say about that.
Mr. Raven?
The defense has no objection to this exhibit being entered into evidence.
Very well, then it will so be admitted. That wraps it up for that first motion. Next up, we will be moving on to the motion to compel discovery of arrest reports, officer statements, and expert testimony provided by the defense. Mr. Raven, if you would go ahead.
Your Honor, would you mind if we approach?
Sure. Okay, we will now be moving to the motion to compel discovery for, once again, the defendant's arrest report, written statements from specific officers, and expert testimony corroborating the statement provided in Exhibit 1 in regards to the packed cash.
If you would accept, we would go do this one by one as before, Your Honor.
Yes, please.
The defense, with regards to the motion to compel discovery, specifically the first section, requesting the defendant's arrest report. The defense believes that the arrest report for the defendant, Frank Raven, is of utmost importance, specifically because it contains information regarding his arrest, the evidence collected during said arrest, as well as, I believe, a small narrative that more or less sums up the approach the officers had during the arrest.
Very well, Mr. Briggs, a response for the arrest report.
Your Honor, the prosecution has no objections for any of the exhibits 1 through 3. Yeah.
Very well. So there's no dispute about me granting this motion to compel discovery in its entirety?
That is correct, yes.
Very well. In that case, I will be granting the motion. Then, just as a quick thing, the previous motion for continuance has been granted, but next up we have the prosecution's motion to compel discovery of defendant's statement and tax records. Mr. Briggs, if you would go ahead and explain your reasonings behind that.
Absolutely. Your Honor, the defendant has been charged with receiving stolen property.
Cough drop attorney.
Absolutely. Can you hear me now?
Yes.
Wonderful. Your Honor, the defense in this case received the charge of receiving stolen property. And for that reason, he also stated that the packed cash that was found on him originated from legal means, providing counseling services, is what he stated. For that reason, we are requesting the source of the cash, as it plays a huge role on, the origination and gives context about the cash that was found on him. And we also would like to see the tax records from Mr. Raven, that he paid taxes to the government to the San Andreas government for the legal counseling that he has done, if it happened, since he is required to do so by the law. That's pretty much what we have to say about it.
Mr. Raven, a response?
With regards to the first section of that motion to compel discovery, the defense asserts that the defendant has the right to remain silent, as has been established by the officers that read his rights, as well as by the laws that this court upholds. Therefore, he will not be, or the defense requests that this motion be denied, as he should not have to present any sort of evidence that might incriminate himself. In regards to point number 2, It is the assertion from the prosecution that the defendant was in the middle of opening a pack of cash. Therefore, it seems unreasonable from the defense's point of view to request tax or bank statements proving payment of tax, seeing as the person in question or the defendant in question was opening a pack of cash that he had yet to be able to pay tax on.
Very well, response, Mr. Briggs.
Your Honor, the prosecution is only trying to figure out what exactly happened and where the pack cash originated from. For exhibit number 1, we understand the defense's concerns, but for exhibit number 2, as we are only trying to figure out by the defense's personal statement that he got the money from legal means, and as the statement will go as evidence, we want to make sure that we have the proper information about that statement. Specifically, since money was obtained, we would only like to see the tax records of money being paid to the government. Otherwise, Mr. Raven will be breaching the laws of the government, since he did claim and specifically admitted to having counseling services. Again, it's something that comes with it. When you sell property or anything or services, the taxes have to be paid. Evidently, this is something that is required to be seen in the court, as if he did provide this counseling, he should have paid the taxes.
Mr. Raven, a response.
Once again, Your Honor, the defense asserts vehemently that the prosecution's request is unreasonable. The defendant did not have an opportunity to pay such tax as he was, quote-unquote, caught in an act by the police, in which case it is impossible or very unlikely that the defendant would be able to pay tax if that same money was seized by the police during the course of opening it.
Very well. At this point in time, Mr. Briggs, I will be denying this motion to compel discovery. Once again, the defendant does have the right to remain silent and not assist in their own prosecution. Therefore, they are not required to submit any statements for that purpose. Should the prosecution have probable cause to believe another crime has been committed, then there are other avenues to handle the investigation of that. However, this motion to compel discovery is not one of them. Next up in the chronological order is the motion to suppress. I'm going to be saving that for last. So at this point in time, we will be discussing the motion to compel discovery of the body camera footage submitted by the defense. So, Mr. Raven, if you have anything to say in regards to that motion. You need a cough drop.
Thank you, Your Honor. I believe the prosecution wouldn't have any point to disagree with this motion to compel discovery. It's 3 basic requests: body cam footage from all 3 officers in the incidents, specifically the 2 initial arresting officers and the supervisor body cam, which ultimately decided the defendant's fate. This goes a long way to establishing a pattern of events, as well as goes to provide the court an unbiased recounting of what has happened outside of the statements that have been given already.
A response from Mr. Briggs?
Absolutely, Your Honor. The prosecution does not have any objections. However, we would like to state for the court that in specific cases, as for Surgeon Bill Breacher and Jeff Babatunda, the footage may not exist. And that happens due to the fact that, number one, police officer Jeff Babatunda is no longer working for the LSPD, and he's not entitled to such information or body cam footage. So it has been requested by the prosecution, but he has denied / said that the footage does not exist. The body cam footage for Mr. Sebastian Papadakis, no objections about that. But the body cam footage of Surgeon Bill Breacher, we would like to state for the fact that the defense stated that Surgeon Bill Breacher might not have been as involved as the defense, has not, in general, has not been involved as much. So we want to see the basis behind the body cam footage for Mr. Bill Breacher by the defense.
Mr. Raven.
Your Honor, the defense stated exactly the opposite of what Prosecutor Briggs just stated. We, without a shadow of a doubt, would assert that Sergeant Bill Breacher's body cam footage is paramount to this case. As I stated in my initial statement, his footage goes to establish a unbiased pattern of what happened during the arrest, including his arrival on scene and then his ultimate decision to arrest the defendant. It was his actions and his words guided towards the two initial officers that sealed the fate of the defendant and ultimately led to him being charged and arrested.
Very well. Final response from Attorney Briggs.
Absolutely. No objection about that. We will be requesting the body cam footage again, as the case is quite old. That body cam footage might not exist, but under the order of the court, we will be trying to obtain that.
All right. Mr. Raven, you're standing up. Is there something further?
I would just like to add, Your Honor, from the defense's point of view, it is very concerning that the prosecution is unable to provide certain body cam footage, especially considering all the officers at the time were informed that this court appeal would be happening, as well as a potential I report, and they were all requested to save their body cam footages, just as an addition.
Very well. Your concern is noted, and just as an aside comment, I was previously informed that officers do maintain their body camera footage for up to 30 days. I believe only 20 days have passed since the incident, so I would certainly hope that some body camera footage would remain at this point in time. So, Attorney Briggs, if you would please reach out to the law enforcement officers involved as soon as possible to ensure that that footage is not lost, that would be appreciated. This motion will be granted.
No objection, Your Honor.
Okay, this leaves us with the final motion, the motion to suppress evidence seized as a result of the search provided by the defense. Mr. Raven, you may begin.
Thank you, Your Honor. The defense asserts that the exhibit number 2 provided by the prosecution, specifically in the first motion to, or the first motion to close discovery, was done so in an unlawful way, and as such should be suppressed. To expand a bit further, the arrest of the defendant in itself was based on the suspicion that he was lockpicking a van. At no point did the officers attempt to identify the man as well as identify the registration of the vehicle prior to seizing any of his items as well as searching him. The defense would also claim that, from what we've already spoken with regards to the first motion that was presented in the court, the prosecution does not have enough evidence to assert that the packed cash was illegal at the time of possession of said packed cash by the defendant.
Mr. Briggs, go ahead.
Absolutely, Your Honor. Your Honor, the prosecution would like to state for the record that Mr. Raven, in his motion to suppress evidence, has stated that, and I quote, "The arresting officers who conducted the search of Mr. Raven's person did so with no lawful grounding as they initially approached him under the suspicion of lock-picking a vehicle. At the time of Mr. Raven's arrest, he had no such lock-pick or any other comparable device in his hand, making the initial reason to approach and subsequent search and seizure unlawful in nature. To start, the police officers have stated that while the initial suspicion was for lockpicking, it was not the sole factor that motivated them. to investigate the situation. Now, Mr. Raven in this case has conveniently left out the fact that while in his hand, where there were no lockpicks device, there was actually a knife. And not only that, but Mr. Raven at the time was also seen wearing a mask, holding that knife next to a bank. The defense is thus claiming that the search and seizure was of unlawful nature, which I believe has no foundation and is a wild claim considering these facts. The police officers acted under reasonable suspicion and according to our rules and basis of our city. In the document named Knowing Your Rights, it states that probable cause is when officers suspect that a crime has been committed, will be committed, or is being committed, which includes the violation of law, citation, misdemeanor, felony, including face concealment. Now, it is obvious that an officer of the law is a human and they operate on logical and reasonable thinking. And correct me if I'm wrong, but not many things outshine the suspiciousness of a masked man holding a knife next to the bank, which not only gives the officers probable cause, but also a necessity for investigation in these circumstances, as their job is to protect and serve the law. Last and not least, Mr. Raven admitted in his own personal statement that he was evidently opening packed cash in a very public space, which contradicts the fact of an unlawful search. He was doing it in a very public space, the police officers could see him, so it was pretty lawful. Now, with this in mind, we request that the motion of suppression is not sustained, and the defense has not provided any other basis for the claim of an unlawful search.
Your Honor, it is the defense's assertion that as stated previously, the approach by the officers were unlawful. Prosecutor Briggs correctly pointed out that the defendant in this case was approached under the suspicion of having lockpicked his own vehicle. It is not a crime in Los Santos to have a knife out. As the Penal Code states, it is only unlawful brandishing of a weapon or firearm if it is done for unlawful reasons. The defendant standing in a public place next to his van in a very public place, simply opening a pack in broad daylight does not constitute an unlawful reason, therefore making the approach and subsequent search and seizure unlawful in nature. To add further, I would like to bring to the court's attention that Prosecutor Briggs' statements, specifically with regards to the defendant's face concealment, are not only incorrect, they do lack foundation from his part, as he has not presented any evidence to support this statement. As such, I would like Your Honor to take that into advisement when deciding the outcome for this motion to suppress.
Mr. Briggs.
Again, Your Honor, the prosecution would like to state that this is not the court and we're not arguing anything here. We're simply trying to provide evidence for the fact that what happened. Now, with this in mind, we would also like to state that the defense is claiming that it was unlawful due to the fact that the suspicion was lockpicking a vehicle. Now, again, as I mentioned before in my initial statement, is that the police officers were it was not the only sole factor that was taken into account, and this can be seen in the personal statements that have been allowed as evidence in this hearing. So we believe that the basis of the search was not unlawful, as it is absolutely suspicious of a man holding a knife, which again is not illegal in our state, but it does open an eye for a police officer when that knife is being holded and opening packed cash outside of a bank, which again ties it to very suspicious activity. And as the police officers are human, they are supposed to investigate such situations as it's their job to do so.
Mr. Raven, go ahead.
Your Honor, it is not the defense's contention here that officers are not able to exercise reasonable suspicion or probable cause during the duties that they have been granted with regards to law enforcement. The defense's statements are very clear, very precise. The approach of the defendant was specifically due to them suspecting that he was lockpicking a vehicle. Once they've established that he was not in fact doing so, they could have obviously identified himself, identified the registered owner of the vehicle, and let him go and be on his way. Instead, they decided to detain the defendant as well as search him and seize his possessions. To which point we contest this as being an unlawful action by the police, as the search and seizure section of the prosecution's own exhibit number 5 states. As such, there was no misdemeanor or felony that was currently happening as the officers had approached the defendant. They merely suspected so under reasonable suspicion and or probable cause. It did not give him grounds to search and seize any sort of items from the defendant unless they had confirmed their original suspicion of there being a crime committed.
Mr. Briggs.
Your Honor, again, the defense is contradicting themselves. We already presented to the court that there was in fact a misdemeanor happening, and that was face concealment.
Objection, Your Honor.
This is
Grounds,
not
Mr.
the
Raven?
court.
Lack of foundation. We have not established yet that the defendant was face concealing, nor has the prosecution presented any evidence whatsoever that states this.
Your Honor, we have presented to the court the personal statements, which number one state that he was masked by Mr. Papadakis. So that is our evidence that we're using.
Could the prosecution point that out for the court and myself, if that's okay with Your Honor? Specifically, the timestamp that is
Mr.
stated
Raven,
where he is masked.
Mr. Raven, this is not the court. If you're trying to suppress the evidence for this, we are only saying that the police officers at the time saw a man that was masked with a knife opening packed cash, which in our city is considered, a very suspicious item. So next to a bank, which gave probable cause to the police officers, and that is the fact of it. There was a misdemeanor being done. That was face concealment. Again, the prosecution has provided the personal statements of Mr. Papadakis, and again, the defense has also requested the body cam footage, which we will be providing. But obviously that was just done now, so we believe that this motion by the defense is very premature.
Anything further, Mr. Raven?
Yes, Your Honor. Just to clarify a few points, perhaps it is from my end because I am representing, and this is new to me. It is my understanding that the court and the hearing for these motions is exactly so that both sides can present arguments and towards Your Honor, so you can either accept or deny a certain motion. I'm not sure why Prosecutor Briggs keeps undermining this sort of procedure, claiming that no arguments can be made. He himself stated very clearly that claims that the defendant was face concealing. He claims that there is evidence currently in the exhibits as well as the officer statement by Officer Papadakis that states that the defendant was face concealing. The defense simply requests that he point that out to not only Your Honor but the defense, as we are totally unaware of this being a fact that is in evidence.
Okay. I believe at this point in time, I've heard enough for today. I will not be making a judgment on this motion to suppress quite yet. I believe the body camera footage that will later be provided by the prosecution will assist me in coming to a conclusion for this specific motion. Therefore, that is the reason why I will not be making a specific decision on that quite yet. I believe that is all of the further motions. Is there anything else that either party wishes to bring up at this time?
Not at this time, Your Honor.
No, Your Honor.
Very well. Then at this point in time, I will thank you all for being here. Thank you to the Department of Corrections for acting as bailiffs for this proceeding. Thank you to the Weasel Entertainment News Network for providing coverage for this. Thank you all for being here, and have a nice rest of your day.